Hello and welcome to the Minimum Competence episode for Friday, July 18th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we have legal fights over Trump's Birthright citizenship order, Epstein grand jury records, and union rights for federal workers tied to national security. Let's remember, you aren't stuck in traffic, you are traffic. And read today's legal news. On this day in legal history, July 18th, 1956, the Narcotics Control Act of 1956 was signed into law, marking a significant escalation in the United States' punitive approach to drug policy. The act built upon earlier federal narcotics legislation, but went much further in increasing criminal penalties and tightening government control over narcotic drugs and marijuana. Under the new law, first-time offenders faced mandatory minimum sentences, and judges were stripped of discretion in sentencing for many drug crimes. Notably, the act introduced the possibility of the death penalty for those convicted of selling heroin to minors. The legislation was part of a broader post-war shift towards strict federal enforcement and reflected growing political and public fears about drug use, particularly in urban centers. It was championed by figures who saw narcotics as a moral and social threat, linking drug control to national security and public order. The law also expanded the jurisdiction of federal agencies, giving the federal government more authority to investigate and prosecute drug crimes that had previously been handled at the state level. Critics at the time and in later decades argued that the Narcotic Control Act laid the groundwork for mass incarceration and racial disparities in drug enforcement. The harsh penalties disproportionately impacted Black and Latino communities and did little to address the root causes of addiction. Nonetheless, the act stood as a turning point in the federal government's approach to narcotics, a hardline stance that would culminate decades later in the war on drugs. A federal judge in Boston, Leo Sorokin, is considering whether to uphold a nationwide injunction against President Donald Trump's executive order limiting birthright citizenship. The order, issued in February, would deny U.S. citizenship to children born in the U.S. after February 19th unless at least one parent is a U.S. citizen or lawful permanent resident. The case is being brought by attorneys general from 18 states and D.C., who argue the order violates the 14th Amendment and would disrupt federal benefit programs like Medicaid and SNAP. The legal challenge has gained new relevance following a June 27th Supreme Court ruling that discouraged lower courts from issuing broad nationwide injunctions. However, the court allowed for exceptions, including in class actions or when needed to provide complete relief. The states argue that a nationwide block remains necessary due to the wide-reaching impact of the order and the need for consistency across state lines. They also contend that the Supreme Court's recent decision does not apply in this particular instance. If Judge Sorokin rules in favor of the states, it would mark the second time this month a federal judge has blocked Trump's order. On July 10th, Judge Joseph LaPlante issued a similar injunction in New Hampshire after finding that children affected by the policy could proceed as a class. The Justice Department maintains that the original injunction was overly broad and asserts that individuals should contest their citizenship status individually. President Donald Trump is now calling for the release of grand jury testimony related to Jeffrey Epstein following backlash from some of his supporters over a recent Justice Department report. The report found no evidence supporting long-standing conspiracy theories about Epstein's death or alleged connections to powerful individuals. In response, Trump labeled the investigation a scam and urged Attorney General Pam Bondi now to release all relevant grand jury material pending court approval. Bondi confirmed shortly afterward that the Justice Department is prepared to ask the court to unseal the documents as early as Friday. Her earlier promises to disclose, quote, a lot of names and, quote, flight logs related to Epstein had generated anticipation among Trump's base, some of whom now expressed frustration over the lack of new revelations. Trump has dismissed concerns as politically motivated fabrications. The renewed focus on Epstein, who died in jail in 2019 while facing sex trafficking charges, has caused a divide among Trump supporters, some of whom feel betrayed by the lack of transparency, while others back Trump's framing of the issue as a partisan hoax. The legal effort to unseal the grand jury materials could reignite public scrutiny over Epstein's connections and the broader handling of his case. A U.S. appeals court appears likely to lift a temporary block on a Trump executive order that limits collective bargaining rights for federal workers in national security-related agencies. The Ninth Circuit panel, composed of 2 Trump appointees and 1 Obama appointee, questioned whether they had the authority to override the president's determination that union activities could interfere with national security functions. The order, issued by President Trump, applies to major departments like Justice, Treasury, and Veterans Affairs, and parts of Health and Human Services. It greatly expands existing national security exemptions by stripping union rights from a much larger group of federal employees. Judge James Donato had previously blocked the order for 21 agencies, citing potential violations of free speech protections for federal unions. During oral arguments, judges expressed skepticism toward union claims that the order was retaliatory and aimed at silencing opposition. The government's lawyer argued that the president has wide discretion in matters of national security, making his decisions largely immune from judicial review. However, one judge questioned whether there are any real limits to this power. The case could significantly impact how workplace conditions are set across the federal government and whether unions can continue to challenge executive policies in court. A ruling in favor of Trump's position would allow agencies to more easily change employment terms and sideline union input. A related lawsuit challenging union contracts is also pending in Texas. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here on Monday, and until then, note, we like to close out the week of shows with a featured musical piece. That will make these Friday episodes seem especially long. We hope you'll stick it out and enjoy the featured piece, but if music, and specifically classical music, isn't your bag, we get it. Our mouth sounds unrelated to the week's closing music ends here. This week's closing theme is by Georg Friedrich Handel. This week's closing theme comes from the grand, imaginative world of Handel, one of the towering figures of the Baroque era. Born in 1685 in Halle, Germany, Handel made his mark across Europe, eventually becoming a naturalized British citizen and composing some of the most enduring works in Western music. Known for his operas, oratorios, and instrumental compositions, Handel blended German precision, Italian lyricism, and English choral tradition into a distinctive style that was both dramatic and deeply human. Among his lesser-known but richly rewarding operas is Xerxes, HWV 40, premiered in London in 1738. Loosely based on the Persian king Xerxes I, the opera mixes romantic entanglements, comedic elements, and royal intrigue, a blend that puzzled its first audiences but has found appreciation in modern revivals. Its opening aria, Ombra mai fu, sung by the title character in praise of a plane tree, is a moment of serene beauty that has outlived the opera's initial failure. Often referred to as Handel's Largo, this aria became wildly popular in the 19th century and is frequently performed at weddings, memorials, and ceremonial events. Xerxes was ahead of its time in its use of shorter arias and flexible structure, which some scholars view as anticipating later developments in operatic form. The character of Xerxes himself, proud, impulsive, and absurdly fixated on love, offered Handel the opportunity to explore both satire and sincerity within the same role. Though the opera was pulled from the stage after only 5 performances, its revival, centuries later, has secured its place in the canon. For all his dramatic genius, it is perhaps the simple ode to shade and stillness, Ombra mai fu, that captures Handel at his most tender. This week, we close with that brief moment of musical tranquility, a Baroque lullaby to a tree sung by a king, composed by a master. Without further ado, Georg Friedrich Handel's Xerxes Overture. Enjoy.